All right, so it's 11 and 7 minutes in the morning, and I suppose it's a good moment to start with this session. Welcome to all of you. It is my pleasure to introduce you to another session of the spin-off competence lab in the framework of the Research U project. And with this activity, I always say at the beginning of every of our sessions that with the spin-off competence lab, our intention at the CU Alliance is to promote entrepreneurship and to promote innovative ideas among our research communities. And in a nutshell, we intend to help you turn your research projects into business ideas. For this, we have organized a series of webinars, which are live streamed on YouTube and then uploaded as in the way of video capsules in a great variety of topics, ranging from business models and lean startup methodologies to grant funding and equity finance, and also an essential part in any endeavor, in any spin-off company you may want to create in the future is intellectual property protection. That is essential, and that was the reason why we held our previous webinar on the 19th of January, and that is why we are having today as well with us Justina Pawlowska from Gdansk. She's a patent attorney who collaborates closely with the university there, with the University of Gdansk, which are a partner of the CU Alliance, and she will be going deeper into the topics that were firstly proposed in the previous session around the topic of intellectual property rights protection and intellectual property rights management. Justina, it is a pleasure for me. It is a pleasure for us having you today again with us. Welcome, and if you are ready, please feel free to begin with your presentation. Thank you. I think that you need to unmute yourself, Justina. We can't hear you yet. Can you try to unmute yourself?
Can you see my presentation?
Perfect. No, right now I can see your presentation. Perfect.
Okay, is it fine?
It is.
So it works. Thank you very much for nice introduction. It's my pleasure to be today with you. So as you know, I'm patent attorney. In order to gain capacity to do this profession, you need to have special education. You need to perform some additional course. For example, in Poland, it takes 3 years. And additionally, you need to pass quite difficult exams. I have experience more than 14 years so far, and working as a patent attorney, it's not easy one, and it's like the triggering with time. And that's why I choose this quotation that you can see on the bottom of this presentation. So before I start, I just want you to know that the presentation is protected by copyright. And additionally, I will use some other photos. So please respect our copyrights law. During the last meeting. So on the right side, you can see the IP objects, and on the right side, the name of the law. So the law that protect particular objects. And the last time we were talking about inventions, and inventions can be protected by patents. Today we will going to continue this problem, this matter, but only with regard to computer program. And of course, very important object of IP is work, marks, logos, or graphics, and traditional and quality of food marks. And we are going to talk about this today. So it's good to understand that the rights set intangible asset, and additionally what you can see, what is material, is tangible assets. And it's good to understand that one object can be protected by several tools. And the good example is, for example, Lego bricks, the red bricks, the very famous one. And the first of all, the matter how to join the bricks to each other was protected by patents. But because of the limitation of time of the patent, the company decided to protect it in other kind of tools and choose design protection and additionally trademark protection. So it's good to understand that one thing can be protected by several tools, and the scope of protection of each of the tools can differ. So the main purpose of IP protection is to gain intangible right, and this intangible right set inclusive rights. So the only owner can use the patented inventions or the protected trademarks, and nobody else can use it without permission. So if somebody will use the patented object or the patented invention or other IP object, that will be understood as infringement of patents. And here in this slides, you can see what activity can be understood as infringement. So it's not only manufacturing, import, use, or market production or selling the patented product, but also offering for sale. So please remember that use of other entities' patent rights may result in lawsuit. And additionally, be careful regarding patent trolls. The patent trolls are entities that protect protect inventions or use another kind of tools, but not show the product at shops. So we cannot see the patented inventions, but of course can be found on the patent database. That's why, lastly, I try to encourage to understand and to use patent database on your daily practice. And additionally, so in this slide, you can see the summary of the function of patents. Of course, you gain protection, so the patent owner gain protection. The protection is limited in time, so it's in general it's 20 years, but it's one changes, so it's one exception, and I will show you during the last slides. And of course, there's some quid pro quo. So in order to gain protection, you need to disclose your inventions precisely and clearly. And regarding this limitation in time, so in general we have 20 years, but regarding some products, some supplementary protection can be obtained for pharmaceutical and plant protection products. It means For this product, the entity needs to obtain approval for launch the product into market. And sometimes the period to gain the approval, it's quite long. And when this period is longer than 5 years, that limit is prolonged. So in fact, the duration of patent is a little bit longer for this period, because of course company tried to apply for patent before trying to get approval registration of product. And it's good to understand some patent trees, some patent requirements trees. So in order to gain patent protection, the invention should meet some requirements. And in this slide, you can see the 3 main requirements. So first of all, the invention should be novel, should be non-obvious, and should be marketable. So should be susceptible for industrial application. And of course, there's some differences between jurisdiction regarding definition of novelty and non-obviousness, but in general, there are some similarities. So first of all, because novelty and non-obvious requirements is checked on the date of filing, it's good to understand and to remember that the publication should take place after the date of filing in order to meet requirements. And as I said you before, we have some exceptions, and here you have the list of exceptions. So the following invention cannot be protected by patents. For example, there are discoveries, scientific theories, aesthetic creations, and program for computers. As such, we are going to talk about possibilities for gaining patent protection for such inventions, and additionally, there are some exemptions from patentability. For example, inventions that are against order public. Do you have any questions so far? I will look at the chat panel.
I can confirm, Justina, just so that you don't have to change your screen, that there are no questions on the chat.
Okay, thank you very much. Thank you very much. So right now we are going to discuss about possibility for protection of a program for computer. So I think that you already know that we are observing 4 IR inventions, 4 IR revolution. And within these categories, we have very important group. There are artificial intelligence inventions. And because this 4 IR revolution, there are a lot number of patent applications from this particular field. And here you can see the top applicants, so who apply for protection from inventions from this category. So first of all, I would like to explain you that program for computer can be protected by copyrights in general. But it's good to understand that according to law, there's some legal definitions. And regarding program for computer, the legal definition is some instructions that is performed on computer that lead to some function, that lead to some results. And regarding copyrights, what is protected, it's only an expression of the idea. An expression, it's implementation of such idea. And on the other hand, many persons can arrive at the same idea, but using different expression. So there is some gap regarding copyrights protection for program for computer. That's why the new thing arrive. Is it possible to protect a program for computer but by patents? And regarding patentability aspects, it's important to discuss some matter regarding mathematical methods, simulation, projecting, modeling, and then the new group of inventions regarding program for computer and its computer implemented inventions, and additionally just a computer program, and of course, as I said before, artificial intelligence and machine learning. So as you saw on the list on exception, there are mathematical method, but only should be in exception should be understood like purely abstract mathematical methods. For example, as you can see in the slide, fast Fourier transform, it's only abstract data and not use technical means. That's why it's accepted. It's not possible to gain patents for such abstract mathematical method. But on the other hand, when the method involves use of technical elements, for example, is performed on computer, that mathematical method that is performed on computer can be possible to assess regarding patentability requirements. And the same is without simulation, design, or modeling. As such, it's excluded from patentability because additionally it means that it's method for performing mental acts, and method for performing mental acts are excluded from patentability as such. That's why right now, according to European Patent Convention, there are one new group of inventions. The new group of inventions is computer implemented inventions. And here you can see the definition. This invention cover computer networks or other programmable apparatus whereby at least one feature is realized by means of program. And what is important regarding patentability matter of that group of invention is that the features which are essential for technical effects are taken into account regarding patentability analysis. But what is important is that the computer program as such and this group computer implemented inventions should lead to technical effects, further technical effects. And in this slide, you can see the real example, what is understand regarding to Patent Office, European Patent Office, as deal with further technical effects. So, for example, invention enabling the detection of the proper function of the AB as a control unit, or for example, computer control process for operating a robot arm or for enhancing a graphic display etc. So the most important is the program for computer or computer implemented invention lead to technical, further technical effects. And here you can see another real example that is treated that this kind of invention lead to gain further technical effects. For example, invention that control a specific technical system or process. For example, X-ray apparatus or steel cooling process, or the invention that lead to separation of the sources in speech signals, or for example a method that providing a genotype estimate based on analysis of DNA samples, or many methods that allow to perform medical diagnosis and enhance this diagnosis. So even if the invention consists of non-technical and technical features, can be regarding patentability, and the features that going to technical effects are taken into account mostly. That's why, according to European Patent Convention, European Patent Office decided to provide some new group of inventions that can be applied for patent. And it's computer implemented method, as you saw in the previous slide, and data processing apparatus device system comprising means for carrying out method performed by a program for computer, or even a computer program comprising instructions which, when the program is executed by a computer, cause to computer to carry out the step, etc., etc. So it's described by methods. And here you can see examples in these slides. It's the big battle between Samsung and Apple. And what you can see on your smartphone is several applications that make some technical effects. And of course, when it makes technical effects, can be taken into account regarding patentability. And the most important thing, as you know, is if the methods deal with lead to further technical effects. And I think that the bounce back features, the bounce back patent is very famous one, and you should know it. Or for example, how to widen some element of the screen, how to scroll, or how to turn the picture that we can see on the screen. And here you have examples of the Apple patents. So as you can see, it's computer implemented method that comprise some steps. And this computer method, it's characterized in that, in response to display of previously hidden edge of the first digital object and continued detection of the first movement, displaying on area beyond the edge of the first digital object, after the first movement is not longer detected, translating the first digital object in a second direction until the area beyond the edge of the first digital object is no longer displayed. And then detecting a second movement and doing the same steps as before. And this is this description of the method claim, of the method inventions regarding scrolling. So this you can see the magic edge that was that's what disclosed before. So this is the movement. Movement is by our fingers. So we move the screen, and when the edge is not longer, when the movement is not longer display, we can see the next object, the next digital object, and here we can see in this example train. Do you have any questions, Juan? Can you check it?
As far as I can see, Justina, there are no questions on the chat.
Okay, so I will continue. We are perfect. In good time. So right now we are going to talk about possibilities to protect artificial intelligence and machine learning inventions. I think that you understand what is artificial intelligence. So the use of development of computer systems that are able to learn. So it's intelligent system. And in fact, the first definition, the first term was used in 1950, but the quite famous was Deep Blue. So AI provided by IBM. And this artificial intelligence bet chess grandmaster. So what was much better than chess master. And of course, we have plenty of new AI. And machine learning is just one subgroup of artificial intelligence that use some predictions factor and of course are able to learn using this prediction. And regarding patentability matter is like some input, some training loop, some predictors in this training loop, and then there are some output and of course some effects of this methods. And of course, artificial intelligence and machine learning can be respected and assessed as inventions regarding patentability requirements, and they are based on computational models and algorithms, and the most famous is neural network. And here you can see the network. So as I said before, we have some input, then we have some training loops, some predictors, and we have some output. And of course, lastly, we can observe effects. And AI inventions can be observed in many fields. For example, medical analysis, translations, drones, pharmaceutical, for example, making some new pharmaceutical. Can you recognize this, let's say, lady? Do you know her? Have you ever saw her? Maybe not in daily use, but maybe on television.
Not me, at least.
No, okay. So right now I will explain. This is Sophia. So Sophia is artificial intelligence that uses speech recognition technology from Alphabet, and she was provided in order to take care of older people. And right now it's quite let's say interesting that she became a citizen of Saudi Arabia. She should be So the producers said that she should resemble the very famous actress. Do you recognize? She's Audrey Hepburn. So I will show you Sophia. It's, let's say, a little bit similar. And this, of course, Sophia is patented program and use speech recognition using neural networks with speaker adaptation. So as I show you, there's some input, some loop, some training loop, and output. So she learned regarding some predictors. Okay, the next case, here you can see some painting. I hope that I found some answers. Do you like this painting? What do you think about this painting?
It is somehow disturbing. It's completely blurred and dark.
Okay. So this painting was bought, a huge of money was spent to buy it. It's portrait of Edmond Bellamy that was created by AI. And AI, this AI was based on two parts. The first part generate new portraits on the basis of works of art uploaded on the system, and the other, the second was verify whether the created image was the result of human or machine activity. And at the moment when the algorithm found that the verified graphic is human work, the process could be completed. And this was the result of this process. And of course, this program was and maybe is still patented. And the next example of AI is AI that wrote the article very fastly. About this particular article was about a Los Angeles earthquake, and it took only 3 minutes for the story to appear online because of using AI. And the last case I would like to show you is that we right now, mostly patent attorneys, are observing one case when the AI was mentioned as inventor. Here you can see the abstract of the invention that was provided by AI. It's just some material for container, and the characteristic of the material is that they are divided into pieces, and the pieces can bind together to produce the bigger part of material. And because according to during requirements, there are of course novelty and non-obviousness, etc. And you need to provide, the applicant need to provide the list of inventor or one inventor if there is only one inventor. And because AI, it's not physical, a person right now, this case is suspended, so was rejected by European Patent Office. I just mentioned that the name of the AI is Taos. So in summary, the most important things is to check if the AI, if the inventions based on a computer program lead to further technical effects. And that's why I will show you 3 examples. And the question is do you think that this invention, let's say, leads to technical effects? And the first example is system and method for accelerating and optimizing the processing of the machine learning techniques using a graphics processing unit. And the GPU, so graphics processing units, it is an integral part of the modern personal computer, and GPU is designed to accelerate the real three-dimensional. So these programs lead to a produce of high quality of holograms. So the system is based on GPU. And the methods lead to transforming the data from CPU, so central processing unit, to GPU, and learn. And the effects is provision of the high quality of holograms. So what do you think? Providing a high quality of holograms is lead to technical effects? Do you think that this is technical effects and patent can be protected? Patent can be gained? Any idea? No. Okay. So yes, in this particular case, I know that it's not easy, but I just want you to let's say be inspired and to understand how it is. It's new area of inventions. So everything is in future ahead of us. So in this particular case, it was a decision that it can be patented, and this program is patented. And the second case is method using image recomposition to improve scene classification. For example, we see some image, but we are not sure what we can see observed. So we have some lake or something, but we want to improve this image. And the system leads to find some important part of the image and improve it. So from this image, we can suddenly see much more with much better quality. And what do you think? Is this system can this system provide further technical effects, so improving the quality of image, so using recomposition, so make good recomposition in order to provide good quality? What do you think? Can it be accepted for patentability because further technical effects? Any answers? So this is the same case. So this leads to further technical effects. I just check if you are still with me. Yeah, you are still with me. Perfect. So the last examples is technique which utilize probabilistic classifier to detect junk emails, so spam. And this system discriminate message, try to find some predictors, and by analysis of the message, try to select which one can be treated by us as a junk, as a spam, and which one as a good one messages. So this program leads to comparison between messages and selected the spam messages and legitimate mail. And what do you think? Further technical effects or no? So in fact, this case was rejected, and according to European Patent Office, it's quite controversial decision. This classifying text documents solely in respect of textual content is not regarded to be per se a technical purpose, but linguistic one, because in this particular case, the messages was analyzed based on letter, based on linguistic characteristics. Okay, I stop. I finished the first part, and then I can go to the next part. So we are going to talk about trademarks. Do you have any questions regarding the last part? Juan, can you check?
Yes, I have checked, and there are no questions on the chat.
Okay, thank you very much. So we are going to talk about other categories of IP rights, and we will start from the trademark. So here you can see examples of the real trademarks. I know that you can find some trademark that you like and that you don't like at all, or you haven't seen so far. So first of all, R in the circle is symbol that should be placed for trademark near to the trademark that is registered. So protected by exclusive right, and shouldn't be used when the trademark is not registered. And what are the requirements for protection of signs? So first of all, the trademark, any kind of the trademark can be signs, words, personal names, should distinguish the goods or services of one undertaken from those of other undertakings. And according to the new definition of law, should be represented on the register of European Union trade marks. This is the definition according to European Union. So should be represented somehow on the register in a manner which enables the competent authorities and the public to determine the clear and precise subject matter of production afforded to its proprietor. Before the change of the law, this requirement was that should be capable of being represented graphically. Right now, it should be just represented somehow. That's why right now we can observe something like non-conventional trademarks, and I will show you an examples. So first of all, trademark which are linked directly and exclusively of the characteristic of the product are refused. So for example, to kind, quality, quantity, purpose, value, geographical origin of the goods or services the trademark is used with. So the trademark should be distinctive but non-descriptive. So not strictly and exclusively linked to the characteristic of the product or services. Regarding category, the list is open. So first of all, words, figurative, mixed, colors, 3D, jingle. And examples. And these examples will come from European Union Patent Office databases. So words. So words mean that the letter, the name, regardless of the graphics, regardless of the colors, regardless of the typeface used with the trademarks. Name and surname can be protected as trademark, the real one and the artificial one. For example, Levi's, Louis Vuitton, Dolce Gabbana, Prada, very famous Kellogg's, McDonald's, Kardashian. Abbreviation, for example, DG. DG stands for Dolce Gabbana. Graphics signs, so without letters, without words. Other examples of the graphic signs. Can you recognize it? What is it? This is Reebok. And this one? It's Honda. And other examples of graphics. For example, fabrics. Burberry, very famous. The next kind of word, the next kind of trademarks, figurative with letters. So we have some graphics and letters. And here you can see examples. Another one. From this slides, you can understand, you can see that in order to gain a broad scope of protection, the company decided to protect not only one mark, but several possibilities to show one mark. So for example, each colors are protected. And of course, in this case, of course, Coca-Cola use this strategy. So apply for protection in many possibilities for showing one trademarks in general. Additional examples. So some marks with small graphical elements. Other kind of trademarks, labels on the bottle and tie on the bottles. Here you can see labels. Conch labels is what we can see when we turn the bottle, and the tie. And only the tie can be protected by trademark, the registration. The other example, and I think that this tie trademark is quite famous for champagne produced by Moët. 3D trademarks, very famous. In my opinion, it's good. Trademarks. Duracell, the bottle, Perrier in these examples. Cookies. And tablets. Pfizer Blue, famous. pharmaceutical product. And non-conventional trademark. Are you with me? I will just check.
Yes, we are with
yes,
you.
everything
Yes.
fine. Thank you very much. So I continue. And next, examples, non-conventional trademark. For example, movement marks. Lamborghini movement marks, so how the doors are opened. First of all, of course, regarding technical matter, this movement, this technical solutions was protected by patents, but because of the limitation in time in trademark, there is no limitation in time regarding protection. Lamborghini decided to protect this movement by trademarks registration. Another example of movement marks, Aquafresh, Smile. Next kind of non-conventional marks, positioned marks. I will open examples from database. And this is how to show movement marks. So you can see that in this we can small part, then it's just set to be larger and more visible. And additional examples, 3D representation of the space. It's layered and was an Apple apply for registration as trademark. Color marks, another kind of trademarks that was registered. It's not easy to register color, but in fact it can happen. So we have Red Bull and Milka. Sound marks, another examples. So this is a description of the marks. So we have some some sound of lion roar. And this particular example is Metro Goldwyn Mayer sound marks. Other non-conventional examples, I think it should be found quite interesting. Let me open website when I will. I hope you will hear it. Can you hear it? Have you seen the trademark and heard? I will check.
Yes.
Yes, okay. So it was real examples of non-conventional trademark. Maybe I will open one more. This is Polish trademark. Okay. I will turn on. So it's movement mark. And let me open one more. The last one, because we have 10 minutes. Quite huge file. Okay.
Thank you, Super Simo.
Just for relaxing you. Okay, let's go to my presentation. Do you have any questions so far? So far, so good. No questions. Okay. So I'm continue. So I finish talking about trademarks. Let's go to next part. So designs. So regarding designs, what is protected is appearance. So the look of the product or part of the product and the requirements. So the design must be new, original, and have individual character. And the novelty mean the design that are applied for registration, apply for protection, shouldn't be identical to design that has been made available to the public before the filing date of the applied design. And even the novelty is understand that cannot differ on material details. So can differ only in immaterial details. And the next condition is individual character. It means that design shall be considered to have individual character if the overall impression that it produces on the informed user differs from the overall impression produced on such a user by a design which has been made available to the public before. And it's good to understand that design protection by design protection, you cannot protect technical elements. So for protection of technical element, you should choose a patent protection. And examples. So this was examples. So some entity tried to gain protection for such designs. It's cookie and show and was shown like this. And because the state of the art was like this, it was rejected finally. Because it's normal, it's standard, let's say standard common cookie regarding state of the art. And another example, some passé, let's say passé designs, jewelry, some elements, the cars. And of course, you know that on smartphones, we can find several patents, and additionally, the appearance of the device can be protected by as design protection. So I just go through examples. And typeface. Some typeface can be protected by design. Icons can found protection by designs. By dotted line, it is shown what is excluded from protection. So here we can see only part is protected by design. So location on the screen, and the screen is shown because it's because on the scope of protection of this design is just location on particular element on the screen. Interfaces, element on the interfaces, how the message look like, icons, and industrial design can, by industrial design, comic character can be protected. Very often Disney apply for protection. And because last time I explained you something about Metaverse, of course, design using in Metaverse can also be protected. For example, icons, some emoticons, displays, projections, video games, virtual interfaces, voices, user interfaces, virtual spaces. And the same like in patent, it's exclusive rights, so nobody else can use protected design. So by protection, the owner gain monopoly. And the duration for designs is 25 years. And I would like to just summarize what should be protected, what should be remembered when somebody wants to protect designs. So the function elements are excluded from such protection and should be novel and with individual character. So we almost out of the time, but because I have 3 minutes, I just want to finally explain that we have additional something like geographical indication, 3 main group of geographical indication, PDO, PGI, and TSG. And it by designation of origin, it's the name that identify products which characteristic it deal exclusively with some geographical region. So when somebody look for protection for some name that such product that are linked, that characterization of this product is linked with some region, some geographical region, this is a good way of protection. Just because when we are going to, when discussing trademark, it's good to stress and emphasize that there are another tool of protection for some product which is linked to geographical region. We have 3 minutes, so I will go to the chat panel. Do you have any questions? Everything was fine, no technical problems. I just want to be sure.
If I can, it seems like there is one question on the chat.
Okay.
However, I am not able to completely.
Yes, okay, I can see it. What is the difference between R in the circle and TM? Or R in the circle?
The final was the C in the cycle.
Ah, okay, okay. It's C. It's very small one. Okay, thank you very much for the question. It's very good question. So as I explained before, R in the circle mean that the trademark is protected by exclusive rights, so it's registered. TM stands for trademark. It's only stressed that the trademark can be protected by copyrights. And C in the circle mean copyrights. I use the C in the circle. I need to share my screen and I show you one more time. So I use it in here. C in the circle. It means that all rights for the presentation are reserved for me. That's why I stress that the rights should be respected and all use of the element and the presentation not pursuant to law should be understood as infringement. Have I explained the question?
Yes, thank you.
Thank you very much for the question. If you will have any question, please do not hesitate to write me an email in any time. We can also arrange some meetings, some discussion. I will be very, very happy to meet your expectations.
Thank you very much, Justina. It seems like we reached the scheduled ending hour. It seems as well that there are no other questions on the chat, so we don't want to keep you busy for more time. Well, there are
Okay,
people
I just
saying
write
thank you.
my email address.
Very good. So, Justina, if I may, I would like to close this session by asking you maybe the last question. At the end of the day, the Spin-off Competence Lab aims to promote entrepreneurship among researchers, and the basics are the essence of every endeavor. So, what would be, very shortly, in a nutshell, your main advice, the fundamental concept that every entrepreneur should have when it comes to IP protection and trademarks, the most essential thing in your opinion? What would be that?
I would like to mention that, in my opinion, and according to my experience, intellectual property protection lead to success, lead to produce prestige between customer and between the company. And on the other hand, it's good to remember that using of the protected entity, protected goods lead to a lawsuit. So it's good to check if launching the product on business will not infringe other entities' rights. So first of all, protection, so gaining monopoly, which allow and enable to provide to gain success. And on the other hand, it's good to remember to not use inventions or other object protected by other entities, other persons. And it's good to be in touch with patent attorneys who advise how to protect and how to avoid infringement.
Fantastic, fantastic. Thank you very much, Justina. Thanks to all of you for being here with us today. Again, to our speaker, Justina, thank you very much for your clear explanation.
Thank you very much. I am very, I would like to give you very thanks for invitation. It was my pleasure to be with you and to work with you.
Very good. Thanks to you. Thanks to you, of course, for your time and your devotion to this project and the spin-off Competence Lab. For our participants, as usual, the recordings of this session will be made available on the YouTube channel of the CEO Alliance, and in the next few weeks we will be delivering to all of you your respective attendance certificates. Thank you very much once again. We hope this session has been useful for you to learn more about entrepreneurship in the framework of research and spin-off companies. And stay tuned, because more activities of the Research You project are to come soon. Once again, thank you. See you soon, and goodbye.
Bye-bye.